The only possible conclusion is that it cannot be said that GCOM was acting unlawfully, because Section 140 prohibits us from inquiring into their deliberations. But what we do know, and the only possible inference that we can draw, is that they were acting entirely correctly, entirely lawfully, when they said to Mr. Lowenfield, your report of 11th July does not conform to our instructions sent to you on the 16th of June, and therefore is unlawful, as was your previous report that was set aside by the CCJ. And therefore, if we treat Ms. Jones' application as bona fide, and we consider the role of the court as acknowledged by Chief Justice George, and as acknowledged in the litany of case law cited by counsel, to smooth this process, the question then arises, how do we deal with this impasse? Now, in my respectful view, and Ms. Kite has said it very clearly, there can't be an impasse with your employee. If you have power to hire and fire, as you do under sections 16, 17, and 18 of the Elections Law Act, and after 2 weeks your employee has failed to do what you tell him to do, the impasse should be very short-lived. He may have collected a salary in June, but shouldn't in July, not after 6 weeks.
Your Honor, this is public interest litigation. Any citizen can bring it, and therefore any citizen is representative of a group or class. Any citizen has brought it in Moore, and any citizen has brought it in David, and now it's any citizen bringing it in Morgan. They are represented by the same attorneys fashioning the same arguments. My colleague, Mr. Khan, pointed out just how much it has gone down that road, and we wish to raise to the court that res judicata issue estoppel must apply. Additionally, we wish to endorse what my friend Mr. Jonas and Mr. Khan has said as it relates to the powers of this court. Guyana's democracy is on its knees, Your Honor. We can't keep doing this. We have to have a resolution, and the resolution respectfully, if we take Section 25 of the High Court Act, along with Section 8 of the Judicial Review Act, as has been adumbrated in detail by my colleague, Mr. Jonas, this court has the power to say to the CEO that you are subject, Section 18 makes you subject to the Commission. The Commission has a power under Article 162 to direct their staff. You have been directed to do something, and you should do as you are directed. And we pray that this court take that step so we do not continuously have to go through these cycles.
This court has to act. It has to act, and it has to act decisively to prevent persistent relitigation of these issues. Or else there would be no end, Your Honors. There would be no end to these elections. In summary, Your Honors, the court should find no difficulty in dismissing the appeal and in upholding the well-reasoned and coherent judgment of Chief Justice George. Unless there are